I'm going to introduce Lee, who's up on the screen right now. Say hi, Lee. Lee Offir is the Florida Regional Counsel for Title Resources Guaranty. And just so you know, Title Resources Guaranty Company is actually also part of that Realogy title group family that I just mentioned. And Lee's firm is actually our title underwriters. So for all of you agents out there, you know that when your buyers get that title policy, that is what Lee and Title Resources does in the background. They're the ones who actually issue those policies. So Lee Offir has been practicing law in Florida since 2006. He's board certified in real estate. He earned his Juris Doctor from Stetson University College of Law in St. Petersburg, Florida, and his Bachelor of Science in Business Administration from the University of Central Florida. And I have a little note here, charge on. He has extensive real estate law experience and a diverse history in the industry, having worked as an issuing agent and Florida State Counsel. Lee has also conducted numerous presentations and lectures pertaining to, but not limited to, various areas of real estate law for groups and organizations throughout Florida. And I have to tell you, this is not our first time having Lee on. He is a terrific instructor on everything real estate law related. Ellen, I'm going to be popping you up on the screen while I introduce you. So Ellen Mitchel, she actually comes to us from RE/MAX Executive Realty. She has been involved in the real estate industry since 1995, and she's actually the co-founder of RE/MAX Executive Realty. Oh, I learned something new today. In 2001, she's a licensed real estate realtor with extensive knowledge in all facets of the real estate market. Ellen's professional associations include the Miami Association of Realtors, the Florida Realtors, the National Association of Realtors, and the National Association of Hispanic Real Estate Professionals, among many others. And one of the designations she has, and the reason that I was so very happy to have her joining us today, is that she is a certified probate real estate specialist. Which means she has received special training to work with the sale of properties that are in probate. And I'm going to let Ellen tell you a little bit more about that in the program. She also volunteers at Children's Diagnostic Treatment Center, Broward Outreach Center, and many other local organizations. She's the past director and chairperson for Florida Realtors, serving on both the Attainable Housing, oh, I like that one, and Communications Committees, and is the former president for the Miami Association of Realtors. She's also a former board member for the National Association of Hispanic Real Estate Professionals. Ellen is the grateful mother of 3 children, daughters Sarah and Heather, and son Kevin, and 4 stepchildren. Oh my, that's a big family. And then last but certainly not least, Mr. Steven Schwartz. Mr. Schwartz is an attorney. He was born and raised in New York, graduated from the Florida International University in 1987 with a bachelor's in business administration, majoring in finance, then earned his law degree in 1998 from the Hofstra University School of Law, making the dean's list, no less. Excellent. Steve is admitted to practice in the state and federal courts of Florida, New York, New Jersey, and the United States Supreme Court. Since 2004, he's had his own practice in Aventura, concentrating in probate and guardianship administration and litigation, as well as estate planning and Medicaid planning. Stephen litigated an incapacity case, including the appeal, which reversed the trial court's decision that relied exclusively on hearsay documents to establish incapacity and set a new Florida precedent for cases determining mental incapacity. And of course, Stephen also holds a real estate license. So again, you all can see, while I'm so excited to have all of these folks with us today, and I am just going to jump right in here and let's get started. I have asked Steve to please give us a little bit of an overview about the probate process and what's involved as far as his perspective as the attorney, in listing and selling a property in probate. So Steve, I am turning it over to you.
Okay, thanks, Melanie, and thanks for including me on your panel today. Again, my name is Steve Schwartz, and my practice areas mainly consist of probate and guardianship administration and litigation and Medicaid planning. My background was in civil litigation before focusing on probate and guardianship since around 2006. And so the first question I'm going to ask and then answer is, what is probate and why should a realtor care about it? So probate is a process with respect to a deceased person of gathering the assets, determining whether there are any creditors' claims, avoiding or paying those claims, and distributing the assets to those people that are entitled to them. So the reason that a realtor should care about probate is because probate presents additional chances for delays in closing the sale and in distribution of the sales proceeds. But just because the chance is there doesn't mean there's going to be a delay. The realtor's job really should be to advise the client where the delays have a chance to occur so as to manage the client's expectations. But it's much better to underpromise and overdeliver. So the basic idea of a probate from my perspective is we open the estate with a petition for administration to obtain letters of administration, which is a document that gives the authority to act on behalf of the estate. Next thing that happens is we publish a notice to creditors, and there are a number of different creditors periods that apply. The most common one that we think about is the 90-day period, which runs from the first date of publication of the notice to creditors. That affects creditors that we don't know. If we don't know who they are, we publish the notice, and that covers any notice that they might be entitled to. But if we actually know about the creditors, we have to send them a copy of that notice, and they get 30 days from when they get that notice, or the 90-day period, whichever is later. And then there's a 2-year period, which runs from the date of death, regardless of whether there's ever been an estate open. After 2 years from the date of death, there'll be no more creditors' claims. So while we've published a notice, we're going to be gathering the assets. Gathering the assets is going to also include the involvement that you have, where we're going to be possibly selling an asset during that time, might be selling a piece of real estate. So there's two issues that realtors should be aware of, I think. That there's probate assets, there's non-probate assets. So probate assets are not subject to the jurisdiction of the probate court. And that includes things like joint bank accounts and life insurance. And it also includes, believe it or not, homestead real property. It's technically not an estate asset. So you might ask, if homestead is not subject to the court jurisdiction, why do we need to get court approval in order to sell the property? And the reason is that the order determining the homestead is obtained from the probate court. Now, most judges are not going to hear the petition to determine whether the property is in fact homestead until after the creditor's period expires, in case there's a potential creditor that might want to challenge that petition. So these issues of navigating the homestead and the creditor period is typically handled by the probate paralegal under the supervision of the attorney. So one of the things that you should probably try to do, make friends with the paralegal who is handling those issues, because there's appropriate times to follow up and then there's inappropriate times to follow up. Sometimes a follow-up will be appropriate within just a few days. Other times it'll be weeks or months. So let the paralegal guide you as when the next step is that would be appropriate for a follow-up. So some of the things that you should think about when you're handling the contract and when you're handling the expectations of your clients is, number one, the title insurance company is going to ask for court approval of the sale. So you should put that requirement into your sales contract. And if I'm the attorney that's involved in the probate, if you don't put the provision into the contract, I will, because it really does need to be there. It keeps everybody on the same page and it keeps the expectations realistic. Another thing that I would ask you, if I'm involved, please leave more than 2 days to accept an offer. Frequently, that provision in the contract is put in. It doesn't cross my desk until maybe the time is even run or with just a few hours left to go. A little bit extra time is needed because you've got an extra couple of people involved. You're going to provide the contract to your client. The client should be the personal representative or proposed personal representative. And if they're doing what they should do, they should ask me to review the contract if I'm their attorney. So instead of leaving 2 days, leave 3 or 4. It'll make a little bit of a difference. One of the things that you should think about is advising the seller that funds might not be available until after the creditor's period is over, especially if you're dealing with a piece of homestead property. You're going to want to sell the property. We're going to need to get an order approving the sale, but we may not get an approval that it's homestead property until after 90 days. And that that the sales proceeds are going to be held in a restricted bank account until that time. So if you're in a situation where you're representing a seller who has to sell to buy, they may not have that the proceeds available for a while. So you need to manage those expectations. Otherwise, your client's going to be unhappy. So your client's going to want to know on both sides of the transaction, are they going to be able to close within 30 days? And what I would suggest is 30 days is possible, but probably optimistic, and 60 days is probably a little bit more realistic. And there's always an opportunity for a delay. One of the things you might want to know when you first get involved in the transaction, are the family members all getting along regarding the probate? If they're not, that's going to be an additional layer of possible delays. If there's a dispute between family members, who's going to be the personal representative? Who's got the will? Is there a will contest? Is the property in a trust, or is it not in a trust? Anytime the people are disagreeing is an opportunity for a delay. Whereas if everybody's going to sign waivers and consents to the sale, it's going to smooth everything out. If you're going to have a situation where you need extensions, get a little bit more time than you think you need. It's always better to have a little bit extra, because otherwise you end up with multiple extensions and it creates a lot more work in the file. The last thing I'm going to mention before I conclude what I have to say is, you know that when the petition for the approval of the sale is going to get submitted to the court, the judge is going to want to know that the sale price is a fair price. So if you have an appraisal, provide the appraisal. If you don't have an appraisal, you're going to want to provide a comparative market analysis. I've had brokers submit to me, a broker's opinion letter, which is their bare opinion with not a single comparative sale. And of course, it got kicked back because the judge wants to know, believe it or not, even if you have a single personal representative and you have a single beneficiary and it's the only person who's involved in the transaction, the judge is still concerned that maybe somebody will come out of the woodwork next week and will challenge the sale, and he'll end up with egg on his face. So if you manage your contract, manage your client's expectations, provide your appraisal, provide your comps, you really should be good to go. And the transaction, hopefully, in most cases, is not going to be that much different than your ordinary transaction. And that's pretty much what I have to say. I understand that there may be an opportunity for questions and answers either now or later, but I'd like to turn it back to Dawn so she can take the next phase.
All right, thank you so much, Steve. I'm going to actually bring Ellen in. So Ellen, you are now up on the screen, and as I mentioned, Ellen has a tremendous amount of expertise from the real estate agent's perspective. So she is right there where most of you in our audience are. And Ellen, I'm going to ask you to pick up from where Steve left off and give us your perspective. I'm also going to ask you to talk to us about your certification and how you think that may have helped, and do you recommend it to folks in the audience?
Sure. Thank you so much, Melanie. And thank you, Steve. I've had the opportunity to work with Stephen, and he's a wonderful probate, guardianship, and elder law attorney. So really good information. From a realtor perspective, there's a lot of additional work that we need to contemplate prior to listing the property. So from my experience, I often get recommended to condos where you'll have the parents, the older parents will have retired in South Florida and their adult children live elsewhere. So you have a unit filled with personal property, furniture, pictures, family items, and since the adult children are out of state, they're not going to know how to go about disposing of these items. They're typically going to come down and take the items that they want. And then there's the additional responsibility typically falls to the listing realtor to assist the family with getting the property ready for sale. So whether that means having a charity come in and pick up the items, having the property cleaned, making recommendations on having the property painted or not, all of that additional legwork will be the responsibility of the listing agent. And so I have developed really good relationships with different charities in our area, as well as consignment shops, depending on the quality of the furniture and the personal property. And most of the condominiums that I work with require that anyone picking up be insured and submit the insurance to the building prior to the date of pickup, the elevator being booked in advance. So just a lot of extra legwork up front as opposed to a traditional sale where people are moving their own items. You don't have to think about those kind of things, let alone be, scheduling and meeting vendors there. And with the probate certification, I have been licensed in Florida since 1998, just because of the nature of our area. I've worked with a lot of probate clients throughout the years. So when I saw the probate certification, I felt like it would give me additional training and knowledge to be able to better serve my clients and support the probate and elder law attorneys that I work with. So the training that I participated in was 2 days in person for the certified probate real estate specialist several years ago. And I continue to get updates from them to keep up on the probate business. So what's different about probate? What Steve had mentioned is really probably one of the biggest things is managing people's expectations in terms of time. When I'm representing the seller and I get a buyer who submits an offer, I'm always going to reach out to the other agent and find out, is the time frame for closing flexible? Because if those buyers are selling their home and need to close and move into the property in 45 days, I wouldn't feel comfortable advising them to do that because there are delays that can come up, and it's important that the buyers of a probate property are flexible in terms of their time frame. It's important to be following up with the probate attorney, and more importantly, as Steve mentioned, with their paralegal. And the relationship that you develop with the paralegal can make or break your opportunity for future business as well. So I know people that have been very dismissive of the paralegal and not really taken the time to cultivate that relationship, treated them more like an errand person. And that's a really big mistake because that person is really plugged into all of the files. They're touching them on a daily basis. And they're also going to have the opportunity to often give a yay or nay to a realtor coming on board for a future transaction, depending on how well they handle the transaction that they're currently working on. So building relationships, whether it's with vendors like movers, charities, the paralegals, probate attorneys, I think that's the biggest takeaway. And also, not all deaths become probate. As Steve can talk to, a lot of properties may be owned in trust and they may pass right to the heirs without going through probate. So it's important to get that clarification from the attorney and find out the time frame from them and what does or does not need to be done, as well as including the language in the sales contract that it's subject to probate court approval, or if there's additional language that the attorney requests. So that is my take.
Thank you so much, Ellen. I appreciate it. Lee, let me go ahead and get you up in here. And good, you got yourself off of mute. Perfect. Lee is going to talk to us again about probate, but a little bit more from the title perspective. What are some of the differences in handling a transaction that has a probated property from the title perspective, and what do the real estate agents need to know about that? Go ahead, Lee.
I appreciate that. Thank you. So from a title perspective, listening to our esteemed guests, I will tell you that I think we have the easy job in all this. Our focus is making sure that there's authority, right? At the end of the day, there needs to be proper authority. The person who executed needs to be the rightful person to be able to execute, and then they need to be vested with the powers to execute. So how do we determine that? We're always going to ask when we see a probate in a title, anytime a real estate deal comes through and there's a probate involved, first two questions we're going to ask are, was it homestead property and was there a will? Those are the most important questions. I'll tell you, technically, homestead property passes upon the instant of death. So let's assume for a second, mom and dad own the property. Dad dies, property goes to mom. Obviously, mom unfortunately passes away with a single daughter that is 18 years old. At that point, the point that mom passes away, and this was mom's homestead property, without a will, that property inures to the benefit of the daughter almost immediately. The problem with title and the title world and how that instant happens is that unfortunately we rely on the public record. And there may not be something on the public record to indicate A, that this was homestead, B, that daughter was the only heir, that C, there was no will or there was a will and it all came to daughter, or D, that there's nobody else that may need to be involved. And usually this is what leads to the title requirement side of probate. So one of the first things that we go back to is the homestead. Now, as you saw Attorney Schwartz talk about earlier, you're not always going to get an order determining homestead right off the bat. Actually, more often than not, you're not going to get an order determining homestead right off the bat until the creditors period expires, as he said. Now, the issue comes, well, you have a deal and it's homestead property, so we already know title is vested properly in the eyes of title law, so to speak, but we don't have a court order determining the homestead of the property yet. So, we have a couple of options. We can always have everybody sign, right? The heirs, the beneficiaries, and the personal representative. Everybody can sign, and so long as everybody signed away their interest, later on there's not going to be anyone to complain. That's using a bazooka to kill a fly sometimes, and sometimes it's using a bazooka to kill a mountain of flies. It just depends on what you're dealing with. The other alternative is to wait the time period. It really depends on if you can get that order determining homestead, because oftentimes it will require a judicial determination as to who the heirs are. We talked earlier about what about if there was fighting amongst the heirs or the beneficiaries. Well, now we can't do anything from a title perspective because we don't know who's the rightful heir or the rightful beneficiary. So the second question that we went through is, once we determined if it was homestead, we have to determine whether or not there was a will, right? If there was a will, that kind of changes the characteristics a little. If there was no will, that kind of changes the characteristics a little, goes to intestate. As the probate attorneys will tell you, a homestead property and an intestate, administration is probably, from a title perspective, one of the easiest way to go. It just goes down to the lineal descendants. And we can get the heirs. A lot of times we can also just do an affidavit of heirship with a deed from the heirs, depending on if the property appraiser is cooperating on that particular day or not. And then from that perspective, we really just take a look. If there is a will, what does the will say? What were the wishes? Who is the personal representative? Is it the right PR? Who are the heirs identified in the will? Is it just going to a trust? So, we ask all these questions from a title perspective when we see it, because we need to know if it was homestead. We go into asking whether or not the individual died survived by a spouse or minor children, right? Because that's a restraint on the devise of homestead property, right? So we have to ask the question if they were survived by spouse or minor child, and if they weren't, then the property is freely divisible. So if they had a will and they wanted to go to ABC charity, even though it was homestead property, technically it could still go to ABC charity, so long as they're not survived by a spouse or minor child. And so, we start with that level of intricacy just because every probate tells a different story. There are so many side roads and forks in the road that you can go on because they're unique. It could be homestead with a will, or non-homestead without a will, or there could be a guardianship involved, or who knows what else, or there might be minor children, right? Now it complicates matters a little more. I can't stress enough from a title perspective, time is your friend, just like our speakers before have let us know that on the contract side, it might take time. On the probate side, it might take time. Well, you guessed it, on the title side, it might take time as well. If we need any court orders, there's a lot going on between, the three parties that you see before you. There's a lot of communication, right? The title company will go ahead and talk to the probate attorney and say, hey, we need this and this particular order. They'll coordinate with the realtors and make sure everything is done what there needs to be done. And, eventually they'll get the order. We deal sometimes with foreign administrations. You know, somebody died in Milwaukee, but they owned a vacation home down here that they used during the winter time, and so they come down here and they say, "Oh well, my Milwaukee court already probated this property, and here's a court order that distributes it to me as the heir." And we tell them, unfortunately, Milwaukee courts don't have the authority in the state of Florida, not yet at least. Even though we do have full faith and credit, we require Florida judges to enter orders with regards to Florida properties. It's just that simple. We can't rely on foreign orders for Florida property. There are easy ways to go about that for foreign administration of wills that you can discuss with your probate attorneys. There are various options, which is another reason why it's important to get your probate attorney involved as early on as possible, as soon as you understand that, you know, this person is passed and what are we going to do with the assets and what are all the questions that you have, even get them started at that point. Because once you start working with the realtor to go ahead and sell the property and get it ready for sale, you're going to want to make sure that you have all your pieces in place so that it's really a smooth process. And truthfully, a lot of times the probate attorney can start probate before you're under contract. So at least the probate is already open. The creditor period already starts to run. They get that ball moving so that when you do find a buyer for that probate property, you don't have to get started at that point. So, you know, it's always important to be open with communication to your realtors and say, yeah, this is my dead Aunt Cindy's, not this is my Aunt Cindy's house, right? You know, let her know or him know from the start that this is an estate property, and make sure that they know to get the probate attorney involved if they haven't gotten them involved already. Other than that, you know, we just want to make sure that everybody receives proper notice. You know, notice is important. It provides everybody with due process in court, so it's kind of important. So if there's a creditor's judgment out there against this individual, or a recorded hospital claim or something to that effect, and yet they weren't provided notice of the probate, you know, we're not going to take the opportunity to discuss legal arguments over whether they received constructive notice because the publication or whatnot. In the title world, you really need to have proof that it was done, or we have to make a risk decision. And that, from our perspective, is basically what we do, right? Your probate attorney will deal with the legal aspect of it, and what we do on this end is we deal with the risk aspect of it, and, you know, how much of what we can do properly and whatever we can't do properly, how much risk does it bring up on titles? And so that's kind of where we go from there. So with that, I definitely welcome any questions. I hope we get a bunch of wonderful war stories or discussions in this Q&A.
Thank you so much, Lee. And we do have some questions starting to come in. And I'm going to go ahead and direct this first one to each of you. So I'm going to ask you first, Lee. Ellen, I'll flip back to you, and then Steve will come back around to you as well. First, a compliment. This is such great information. So they're saying thank you for that. And what are some additional sources for probate information that would be valuable to the real estate agents out there?
From a title perspective, depending on how technical you want to get and how late at night and how much you want to sleep, right? There's always, I say it all the time only because it's such a widely used resource amongst all real estate practitioners in the state of Florida, is the title notes that are published out there. And, you know, you can ask somebody, one of the realtors might have a copy that you can get. There's a chapter on administration of estates. I know the Florida Bar does, the reptile section has a search bar on their website. Their website is rpptl.org. And within that search bar, if you search probate, all the reptile articles are in there as well. And one more resource is the FLTA, the Florida Land Title Association. Feel free to go to their website as well, or contact them, and they have a plethora of title-related probate resources as well. And finally, obviously, go to your title company, right? Go to Sunbelt, go check it out and ask questions, and, you know, they'll get you the resources you need as well.
I'm sorry, I left myself on mute there. I apologize. Thank you so much, Lee. And for everybody out there, I was typing as fast as I could to put some of those resources into the chat box for you. Ellen, I'm bringing you up on screen. From your perspective, what are some resources that are out there for the agents?
Sure. In terms of for the realtor, I would say the resources would be to get a relationship with a local charity that has the proper insurance to be able to move items that the heirs are going to be donating to get the property vacant, and really have a team of professionals around you. So you want to have a cleaning person, you want to have a mover, you want to have a charity that can take charitable donations, and really work closely with your title company from the beginning, as well as your probate attorney. But those, you could almost be certain that you're going to need a mover, a charity, a cleaner, and your title company. Very, very important pieces to the puzzle.
Ellen, you actually just answered one of the other questions beautifully. The question was, do you recommend having a list of go-to people to handle some of those extra services? And I think you absolutely just answered that. Thank you.
Yes, I do. I have a list of vendors. Some of the charities in South Florida, you would be surprised, you'll call for pickup and they don't have insurance that allows them to pick up over the first floor, above the first floor in a condominium building, where the condominium building is most certainly going to want to be listed as an additional insured for their insurance. And if it's not on the first floor, they're going to have to be able to provide insurance, for that as well. So making sure that you have that charity, and also a company that can do clean out. The charities are only going to take some of the contents. If you have really old or things that just need to be trashed, having a clean out company is another good vendor to have at your disposal. So cleaner, move out company, charity, painter, all of those things to have at your disposal.
Excellent. Thank you so much, Ellen. Steve, I'm bringing you up onto screen now. The same question. What are, besides your firm itself, what are some great sources for probate information?
Okay, thanks again. Well, all the probate information, the playing field is going to start with the statutes, which is going to be found in chapters 731, chapter 732, and chapter 733 of the Florida statutes, which you can find online. And you may have a particular issue that you could take a look at. And as any attorney will tell you, you can't just start with reading the statute, because reading the statute might give you the impression that the statute means a particular thing, and it's not until you read cases that construe that statute that you learn what the statute really means. So you can look at the statutes, you can look at the cases. You might not necessarily want to spend all the time doing that, which is, why you can use, an attorney like me, because I probably know the information off the top of my head, or I can find the answer to the question a lot faster than you can digging through, 3 chapters of the Florida statutes. But if you wanted to do one thing each year to really educate yourself, you should see if you can go to the reptile section, legislative and case law update, which is at the breakers each year at the end of July. It's a very fast moving seminar. It's the best seminar that I attend. I attend it every year. And what it does is it tells you all the changes that have taken place in the law over the past year, either because there was an appellate decision that came out that made a change, or there was a change in a statute. There's a new statute that's been enacted. One of the most important statutory changes that I learned of in that section was a change to the Homestead Law. It used to be that the surviving spouse got a life estate and the children got a vested remainder, but that actually was a big problem, because sometimes the surviving spouse would end up with an interest in a piece of property that they couldn't carry it, because the life tenant's obligation, as you mostly know, has to pay the interest on the mortgage and has to pay the taxes and the insurance. And if they're in a position that they can't pay that, then the remainder men can file a lawsuit to put that life tenant out. So they made a change to the law that said that the surviving spouse had an option that they could elect to take a tenancy in common, with the children taking the other 50% in common. Why is that important? It's important because in a partition action, which is a lawsuit to force the sale of the property, you cannot partition against successive interests. So the life tenant is called the present possessory interest, and the remainderment is a future interest. Partition does not lie. You can't partition that way. But if it's a tenancy in common, then you can force the sale. So the whole idea with the homestead being to protect a surviving spouse, sometimes it doesn't work out that way. This legislative change, which I learned of in that seminar, actually affected that change. So if you get a chance to go to that seminar, I would definitely encourage it. Everybody will learn something, whether you're dealing with commercial real estate, whether you're dealing with residential real estate, there's going to be something there for you.
Steve, both you and Lee actually mentioned this, and I'm hearing it as reptile. Could you please spell that so I can put it in the chat?
RPPTL, Real Property, Probate, and Trust Law section of the Florida Bar.
Okay, folks, I got it in. Well, I guess you are sort of kind of pronouncing it like reptile, aren't you?
Yeah, from one reptile to another.
Okay. All right, so I'm going to keep you on the screen because we did have another question, and I'm going to ask for both you and Lee to answer this one from your perspectives. Does a will have to be officially done by an attorney or notarized, or can it just be a written letter signed by the deceased? So if you could take that from a probate law perspective, and I'll have Lee take that one from the title perspective.
Okay, this is one of my favorite areas because it leads to lots of additional fees for me. So since out of self-interest, I'm going to tell you, don't have anybody go to an attorney for a will. They don't really need one. They can do it themselves, just like if they were going to do a surgery, they don't really need a surgeon. They can operate on themselves. Of course, I'm being facetious. Legally speaking, you can do your own will. There are very technical formalities that do apply to the execution of a will. I would not recommend that you do it yourself because it's not just a matter of preparing the will yourself. It's a matter of where you're going to keep it. Are there people that are going to be interested in challenging it? And there's a lot of additional advice that goes along with just doing the will. I was involved in a will contest a few years ago where the woman was worth about $1 million. She hated her daughter, but hated her daughter in the worst possible way, and really loved this person from her church and did the will in favor of the church member. It was not done by an attorney. It was done by a, let's call it a do-it-yourself kit with a very famous person's name attached to it. And what happened? The will was never found. Only a copy was found. And so when you don't find the original, there's a presumption that arises that the will was destroyed with the intent of revoking it. And so that was what the fight was about. Was there an intent to revoke the will or not? And at the end of the day, the case settled for 50-50. So the decision not to have an attorney do the will, which would have cost $1,000 or $2,000, something like that, cost $500,000. So, and that's only because the person was worth $1 million. It could have been more. If you really want your property to go where it's supposed to go, have an attorney do it correctly, because there are a lot of opportunities for a mistake, most especially if you are dealing with a situation where you have a blended family, it's a second or third marriage, there are children from both marriages, there are surviving spouses, maybe there's obligations for under a property settlement agreement. You're just asking for trouble if you do it yourself. Can you legally? Yes, there's no legal requirement that it be notarized. There's no legal requirement that an attorney do it. Now, the self-proof affidavit needs to be notarized. So if you want it admitted to probate a little bit more easily, do a self-proof affidavit and get it notarized. But again, my advice to you, do not do it yourself.
I saw Lee nodding his head vigorously through most of that. Lee, what did you want to add to it?
Obviously, aside from echoing those sentiments, you want to make sure, you know, it's not just the proper language that needs to be used. There's also a proper way for you to execute in the presence of witnesses, and obviously, you know, if you're doing the affidavit, the notary as well. I've seen wills that are done by themselves, and I can tell you from a title perspective, more often than not, it doesn't assist in the title process. The easiest way to get a will admitted without contest is have an attorney that's doing it from the beginning, understand everything that's going on, right? So, you know, if you have clients that you're referring to an attorney for a will, and you already know, or your clients already know, that there's some issues with regards to a disinherited brother who, might come creeping up at any point in time that nobody's heard from in 20 years. Well, if you don't get that issue resolved in your will on the outset by making certain express declarations or making it clear as to what the intent is from a title perspective, you might get caught having yourself in a closing searching for a brother that you haven't known where he is for the last 30 years in order to properly or fully convey insurable title in that aspect. So yeah, I can't stress it enough. Go to a professional to do your wills. Make sure that they're executed properly, and then obviously get them admitted and get the intent. Make sure that it's clear. Basically, that's kind of it.
Can I add one more point?
Absolutely, Steve.
So one of the things I learned from an attorney in my office, he has a real estate practice, is when you have a piece of real estate, the will is the document of title. It's exactly the same as if you had a conveyance between two living people, and how would you transfer title? You would use a deed. So when you don't have a living person, you have a deceased person, that will is the document of title. So the same way you likely wouldn't prepare your own deed, although could you? You could, but you shouldn't. You really want to make sure that if you're going to have a piece of real estate that you do have an attorney do it, because that will is the document of title that's going to transfer the ownership to the next person who's going to own it.
That's an excellent analogy, and one that I think our audience can definitely understand. Thank you. Lee, I'm going to bring you back in because I'm going to direct the next question to you. So if there is some sort of a judgment lien against the property and the heirs do not pay it, I'm not sure how exactly, do not pay it, and the title company do not pay it at the closing, what happens?
If the property is subject to a lien and it's not paid at closing, then the buyer takes it subject to that lien. If they'd use the title company, ostensibly they have title insurance. And so if there's a lien that should have been paid that wasn't paid, they might have a title claim on their hands. But the reality is, if there's a valid lien on the property, then it would remain as far as being subject to if it's not paid. Yeah.
Okay, perfect. Ellen, I'm going to bring you on up because the next question is going to you. As a buyer's agent, what questions should we ask the listing agent with reference to a property in probate?
Great question. I would ask if the probate has been opened yet and what the time frame was that we were in the notice to creditors. So typically, it's not going to close. It's often not going to close in that first 90-day notice to creditors. So I would ask if the notice to creditors has been opened and where we are in that time frame. I would also ask if everything looked like it was proceeding smoothly with the distribution of, if everything was going smoothly in the probate process. So as Steve had mentioned and Lee had alluded to, if there is disruption among the heirs, that can signify that there are going to be delays. So I would just ask, is everything going smoothly? You may even ask to speak to the probate attorney or their paralegal just to see if there's any language that they would like to see in the sales contract and confirm the time frame with them. Like, we're writing a 60-day closing, we're writing a 90-day closing, is that sufficient? And get some direction from them while you're preparing that sales contract.
Excellent, Ellen. And I'm going to direct the next question to you as well. How do you market yourself as a probate professional, as a realtor?
Sure. So what I do is I create relationships and provide value and support to probate attorneys. So my job is to make their job easier. And if I can be that solution for them, hey, when you get a probate property in Florida, I can take care of everything from A to Z. I'll be happy to handle the redistribution of personal property. I'll be happy to go and meet the locksmith there if the property needs to be rekeyed. I can go and take an inventory of the personal property, a photo and written inventory of the personal property to provide to the heirs. So my job is to be the heels on the ground for them and to make them look good and to make their jobs easier. So anything that I can take off of their plates, I'm going to let them know that I'm their person.
Excellent. Thank you so much. We've actually got we have a pretty amazing audience out here, I have to tell you, because some of these questions are getting rather technical. Steve, I'm bringing you back up on the screen. And let's take this one. I'll direct it to you first and then to Lee, but I got to find it again. I'm so sorry. There we go. If the tenancy changes during the length of ownership and there is no continuous marriage, do we need probate?
I'm not sure I understand the question in terms of what you mean by the tenancy. If you mean that can I get the person to clarify the question?
Yes. So Juan, if you could clarify on that. Let me move on to the next one. Okay, so what exactly happens when the 90-day probate runs out? The attorney comes to you with results, assuming no one has come forward in 90 days, then what?
Okay, and that's for me?
Yep, we'll do that with you, and then we'll also ask Lee. Okay,
perfect. So the 90-day creditors period, just to be clear, first of all, it applies to unsecured creditors claims. If there's a mortgage on the property, that's not has nothing to do with the creditors period. The 90-day period applies to creditors that are not known or reasonably ascertainable, and that's the legal standard. Known or reasonably ascertainable creditors. So it's conceivable that you could have a creditor that comes along that says, I'm a known creditor and I was never given actual notice. And I've had that happen, you know, just within a few weeks before the 2-year period runs out, the 2 years from the date of death, saying, I never got notice. I'm a known or reasonably ascertainable creditor, and I should have been given notice. And so they're going to get then an actual notice, which is going to give them 30 days, an additional 30 days up until that 2-year period. But what that really means is at that point, there shouldn't be any more creditors, which means you should be relatively free and clear to get whatever orders that you need from the probate court. If you need an order approving the sale, assuming that all the interested persons are in agreement and they're signing waivers and consents, the judges always want to know that everybody's in agreement or that they don't have a basis for disagreement. So if all the interested persons are signing waivers and consents, you submit those, you get your order. If you don't have waivers and consents, then you set it for a hearing, and then, you know, I, on behalf of my client, will make the argument to the judge why he should or should not sign the order, and the other attorney will make an argument, and the judge will resolve it. So just to conclude the answer to the question, at the end of the 90-day period, we've eliminated, in theory, the known, not the known or reasonably ascertainable creditors, but all the other creditors, those that are not known or reasonably ascertainable. So I hope that answered your question. If not, ask one that clarifies it. I'll try to do better.
All right, and Lee, did you have anything to add to that from a title perspective or a law perspective?
You know, just to go over the first interpretation of that question, so to speak. The question was, do we need probate if whatever scenario changes? And I want to touch on that for a brief moment, because from a title perspective, you don't always need probate. Like I said before, if it's homestead property and the decedent died without a spouse or minor child, and there's only one obvious heir, and then that's, you know, we're certain that that's the lineage of heirship. You know, from a title perspective, we don't necessarily need probate in order to convey title and move things forward. Now, that said, like we said, the last thing you want is to get caught in a situation where you could have had probate done and it was fairly quickly and you could have just gotten the orders and there was no other issues. Or, you know, I know the realtors will say, I've never had a client lie to me before. I swear to God, I'm the only heir, right? Well, you know, sometimes that doesn't necessarily happen. So you really want to avoid these things. And if you're able to get into probate, you can really do a lot as far as getting whatever orders you need with regards to authorization for even the personal representative to sell. And, you know, if we need to hold the money in the probate attorney's trust account while we proceed to closing, there's a lot that can be done once you involve a probate attorney and you go into probate. So, yeah.
Okay, and I think that probably answered Juan's question. He did come back and clarify that he was talking about a transition from tenancy in the entirety to tenancy in common and what kind of an effect. But I think, Lee, you did just answer that for him. So if not, Juan, please don't hesitate to come back. And Lee, I'm going to direct this next one to you as well. How would a reverse mortgage, I guess, affect from a title perspective when we're talking about a property in probate? How does it impact the sale of the deceased person's home? Does it add anything to the timeline? Just kind of the reverse mortgage hair in the sauce.
Yeah, and I'll tell you, and I think perhaps maybe Ellen wants to add to this a little, but what I was thinking as far as the title perspective goes, it really just, I mean, it's simple and it's clear cut. It either is or it isn't from that perspective. You know, I don't think that it would make a difference one way or the other from our perspective, so long as the proper people are signing and getting that out.
All right, and I'm going to take your advice, Lee, and I've brought Ellen up on the screen. Did you have anything you wanted to add to that? Basically, the question is, you know, if the homeowners had gotten a reverse mortgage on the property and then now they're deceased, how is that going to affect the property in probate from your perspective as the listing agent? Actually,
Mel, I do have one more thing I wanted to add on there as well.
All right, and I'm gonna flip back over to you because Ellen, I think you may still be on mute, maybe. Go ahead, Lee.
All right, so from kind of just to clarify where we were going, either it is or it isn't. The reverse mortgage is a mortgage on the property. If the property is being sold, the buyer doesn't want to take the property with a reverse mortgage. So either the mortgage is on the property or it isn't. It's pretty clear cut. If we're going to pay off the mortgage, if we're going to satisfy, release the lien, then you go ahead and go the route of paying it off. They want the property, they want to be able to sell it, whatever it is, right? If they don't and the reverse mortgage stays on there, then either the reverse mortgage company will take the property back, or you'll have a buyer that's going to take it subject to, which, you know, I don't know which buyer was going to want to take a property subject to a reverse mortgage, but, you know, it's South Florida. I've seen crazier things happen.
Yeah, I think, though, the typical buyer is going to want any type of mortgage paid off. Ellen, let's see if I've got your audio back. I'm not hearing you. You don't seem to be on mute, but maybe if you can kind of click that button a little bit. And while you're doing that, I'm going to pull Steve back up real quick. I've had several people asking for you to repeat the name of the seminar that you talked about earlier, the reptile one. That's the RPPTL.
It's the Real Property, Probate, and Trust Law section of the Florida Bar Legislative and Case Law Update.
I can't type that fast.
Legislative and Case Law Update.
Legislative Case Law and Update. I still missed something in there. The section of the Florida Bar?
Real Property, Probate,
Real Property,
Trust Law. Reptile.
Real Property.
Lee, don't you like reptile better?
I
do. I really do.
All right. So I got that into the chat there for you all. And by the way, we are just getting a lot of kudos that they've really appreciated this seminar today. So just a super quick question. I think it should be a little bit obvious. Do you on the will? Everybody was talking about the wills. Do you want to update those with your attorney throughout the years?
Yeah, it never is going to hurt for you to check with your attorney, but usually it's going to be because of either of two reasons. Either you had a change in your family situation, or there was a change in the law somehow that might affect what it is that you're trying to do. So you're going to know if you had a change in your family situation, if you had a marriage or a divorce or a death in your family, or perhaps you named somebody as a personal representative and now that person has died, or now you hate that person. So you're going to want to You can look at your will periodically just to see if there's any names in there that you're not happy that those names are in there.
Okay, thank you. Lee, I'm going to bring you back up real quick. This was kind of following up on the judgment question, and it was to clarify. The judgment they were asking about is actually on an heir, not on the estate property. So is the title company worried about that? Does that need to be cleared?
Awesome. That's a really good question. And that question in and of itself is one of the main reasons why you need a probate attorney involved in probate cases. If an heir has a judgment against them, and at some point the property is devised to that heir, that judgment has a great likelihood of attaching to the property. Now you've just attached a judgment to a property that didn't have a judgment beforehand. If there's a way around it, if there is a way where in the will, the PR has the authority to convey the property, regardless of whatever it is, and you have a probate attorney draft whatever they need to in advance, there might be an opportunity to devise the property and insure title without actually having to attach that lien to the property or pay off that lien afterwards. But it is dangerous when you're dealing with that, because anytime, for example, if it was mom's homestead and mom passed and John got the property and he's the only heir, but John has a ton of judgments against him and this isn't John's homestead, well, those judgments are more than likely going to attach. And so it's always good to talk to a probate attorney beforehand, make sure that we set up the documents with proper authority to give yourself an opportunity to, get what your goal is without hurtling yourself through attaching judgments on your own. Really.
That goes back to the previous question, if there's a reason to update your will. And the answer is yes, because if you know that your beneficiary or one of your beneficiaries is a judgment debtor, then you can take steps in your planning documents to work your way around that.
Oh, that is terrific. And I love how all of that just kind of works right together there. Thank you. Yeah, I learned something new today too. Thank you guys. Ellen, I'm going to come back to you. Can you let me know if I can hear you?
Can you hear me?
I absolutely can hear you. Welcome back. Thank you.
Thank you.
So I'm gonna have the last question is going to be for all three of you, and then we're going to just take a minute to do any kind of final thoughts that any of you have. So Ellen, what is the longest and shortest term of probate you have seen?
Well, shortest is when I'm hired when the notice to creditors is already well underway. So 30 to 45 day closing when we're already have the notice to creditors well underway. Longest, I've had a couple of years. I've had some larger estates where the heirs were fighting and it took a couple of years, but that's not typically, it's not typical. Typically when I'm referred a probate case, it's a 60 or 90 day closing. So
excellent. Yeah, I'm glad you said the 60 to 90 is more typical, because 2 years I was like, whoo.
Yeah.
Steve, I'm going to bring you up and ask you the same question.
Okay, sure. So the fastest probates that I've ever done start to finish was 6 months. Happened twice, and I always tell people 6 months is lightning fast. That's like when you go to your friend's house across town and you hit every green traffic light along the way. You might remember it once, but you're more than likely that you're going to hit every red traffic light. A typical estate, start to finish, will take 1 to 2 years, but that doesn't mean that your probate sale is going to be in that 1 to 2 year period. The 1 to 2, your probate, your real estate sale is probably going to be a few months. But the longest estate that I can tell you about that I know about is one that I got involved in recently, but the decedent died in 1997. And he died in a foreign country, but he did own a piece of property here. So we had to open a probate here in order to complete the transaction, as Lee was saying earlier, because while the state may be obligated to follow the full faith and credit, the title companies aren't, and they're not going to write title if they don't feel like they want to. And if they don't write title insurance, the buyer's not going to buy. So this from 1997 to now. So what's that, 25 years and counting?
Wow. It sounds like you and Lee and Ellen can get together and write a book on this.
Probably.
Lee, I'm bringing you up to ask you the same question. The longest and shortest real estate transaction you've been involved in that involved probate.
You know, I'll tell you from a title perspective, again, I think we get off a little easy here because really our involvement is once the property is already under contract and the parties hopefully by now have had the conversation that, you know, we might need an extension or they've given enough time and where are we on the probate? How have we decided? You know, we'll get a file sometimes that people will say, well, it's in probate. Okay, well, what are we doing with the property? What has the estate decided? Which route are they going to take? And oftentimes it results in a conversation with the probate attorney. You know, from depending on where it comes to the title company's office, you know, it could be as quick as you know 90 or 100 days, depending on if you need to wait for the creditors period. Sometimes you can get a rush order in a lot sooner than that. It really depends. You know, for the most part, the biggest holdups are going to be your creditor period. So you shouldn't wait to get something started so your creditor period could start running. If there's any, you know, outstanding disputes or claims, you want to get those resolved as soon as possible. Any other beneficiaries or any disturbance really that's going to cause a dispute. The last thing the title company wants to see is anybody fighting. At the same time, waivers and consents, when they're signed and everybody agrees, let's assume for a second we have 5 beneficiaries and they all signed waivers and consents for all their interests to go to one beneficiary. Well, from a title perspective, that might not work as well. So it's really important if you want to keep your time with the file in title to a minimum, it's really important to make sure that you're using your probate attorneys, make sure that you're communicating with regards to what you need to do on the with your realtor and as far as getting everything ready in advance. And then as far as it goes from the title company, you're going to want to make sure that they know how they're selling the property and kind of where it's going and who's involved, and they'll do whatever it takes to get it done the fastest. You know, sometimes we don't even have to wait for probate depending on the situation for title. It just depends. Like I said, every probate story is going to be different. So how quickly can we get it done? It just varies.
Excellent. Thank you so much, Lee. All right, so we are just past 3 o'clock. I'm going to give you 15 seconds to give us anything else that you want the audience to know. And I'm going to do the same for you, Steve, and then Ellen will come back to you. 15 seconds, Lee.
Folks, it was a pleasure for me. I'm not going to take up all 15 seconds. Be sure to reach out to Sunbelt or Melanie Don if you need anything.
Thank you so much, Lee. Steve, 15 seconds for any last thoughts that you want the audience to know.
Don't do your will yourself. Come to me for the probate as early as you can.
I think that is perfect advice. And I do have Steve's contact information over there in the Q&A. And Ellen, 15 seconds for any last minute advice for all of our audience out there.
Sure. Thank you so much again. I would say just be a good student, always be talking to your professionals, wanting to serve, and take that information and do the best job that you can for your clients, and the business will come and flourish. So
I think that's excellent advice, Ellen, and I think you ended us on a perfect note. So I'm going to thank our audience again. And by the way, the audience is, everybody out there is still thanking all of you as our panelists. They really enjoyed the conversation today. Again, please feel free to reach out to Ellen if you've got referrals from other parts of the state, or you want to talk to her about the certified probate real estate specialist credentials. Be sure to reach out to Steve if you have any referrals over to him for any kind of probate or elder care files. And of course, Lee is always available for questions about title and all sorts of great things. Thank you so much for joining us today. We look forward to seeing you on our future programs. And I look forward to seeing Ellen and Steve back for future programming here as well. And Lee, I know you'll be around, so we'll see you soon too. Have a great day, everybody.
Have a great day.
Thank you, everyone.
Thank you.